Welcome to Nkechi Taifa's nostalgic and amazing blast from the past. Journey with us back through time and enjoy as we dust off historical gems from months, years, and even decades ago. Nkechi Taifa is considered by many a true warrior lawyer. She is also a best-selling author, an audacious advocate. Please enjoy Nkechi Taifa's Blasts from the Past.
It is amazing what one discovers when you rummage through old stuff. I just found a gem of a video from 2017 where Judge Ketanji Brown Jackson, judge at that time, U.S. District Court judge, now Supreme Court Justice Ketanji Brown Jackson, is listening intently to remarks I made as a panelist at a panel dealing with criminal justice reform at GW University. Enjoy.
All right, everyone, welcome back from lunch. I am pleased to introduce the participants in panel number 3, Looking Forward, Criminal Justice Policy and Reform. First, I will introduce our distinguished moderator, Judge Ketanji Brown Jackson, who received her commission as United States District Court Judge in March of 2013 after her nomination by President Barack Obama and confirmation by the Senate. Until December of 2014, she also served as Vice Chair of the United States Sentencing Commission under Chair Patty B. Saris, who we heard from yesterday. Judge Jackson previously focused on appellate litigation as of counsel at Morrison and Forster, right across the street here, and handled criminal appeals as an assistant federal public defender in Washington, D.C. She clerked for 3 federal judges, including Judge Patty Saris, now Chief Judge Patty Saris on the U.S. District Court for the District of Massachusetts, Judge Bruce Selya on the U.S. Court of Appeals for the First Circuit, and Associate Justice Stephen Breyer of the United States Supreme Court. Judge Jackson is currently a member of the Board of Overseers of Harvard University, and she serves on the Governing Council of the American Law Institute. She also currently serves on the board of the D.C. Circuit Historical Society. And as I always embarrass her when I introduce her, she also has the distinct honor of having seen my halting courtship efforts because she was my wife's college roommate. And so, yeah. So yes, lots of information she has for you. Nkechi Taifa, who is Advocacy Director for Criminal Justice at the Open Society Foundations. Her areas of expertise include federal sentencing reform, law enforcement accountability, prison reform, reentry, racial justice, and executive clemency. She's also the founder of Justice Roundtable, a group that I belong to, an advocacy coalition advancing federal justice reforms, which was instrumental in the passage of the 2008 Second Chance Reentry legislation and the 2010 Fair Sentencing Act. She served 7 years as founding director of the Equal Justice Program at the Howard University School of Law and as an adjunct professor at both Howard and at American University Washington College of Law. She was a legislative counsel for the ACLU, public policy counsel for the Women's Legal Defense Fund, and a staff attorney for the National Prison Project. She's received numerous awards for her social justice advocacy and accomplishments, and as a private practitioner, she represented indigent adults and juveniles and practiced employment discrimination law. And she is a graduate of the George Washington University Law School. So I'll mention that. And with that, I'll ask you to join me in a round of applause for our panel.
Good afternoon to you all. Dean Fairfax has already done the heavy lifting of giving you the information about our panelists, their distinguished and impressive bios. And I think the only real function of a good moderator is to keep the trains running on time. So I will start.
Hey, Ms. Taifa.
Okay. May it please the court, counsel, members of the jury. Judge, I really miss those days. But anyway, I really want to thank my alma mater, GW Law School, for inviting me here this afternoon. As a staff attorney for the National Prison Project during the mid-1980s, I often cited in my conditions of confinement briefs the 1957 case of Trop versus Dulles, which quoted Supreme Court Justice Warren's statement, which stressed the importance of considering, and the quote is, the evolving standards of justice that mark the progress of a maturing society. I'm going to repeat that. The evolving standards of justice that mark the progress of a maturing society. And as we move forward, I've often wondered, have we evolved? During the height of the war on drugs, unnecessarily lengthy sentences were robotically meted out with seemingly callous abandon. Shocking punishments over the past 30 years of 10, 20, 30 years and life imprisonment for drug offenses were commonplace. Such punishments should have offended our society's standard of decency, but they did not, and they have not. So, lengthy sentences for drug offenses are cruel, but they are usual. And they became usual with the advent of the 1984 Comprehensive Crime Control and Safe Streets Act, which eliminated parole in the federal system. 2 years later, the 1986 Anti-Drug Abuse Act established mandatory minimum sentencing schemes, as well as the infamous 100-to-1 quantity ratio between crack and powder cocaine. And then 2 years after that, the 1988 Act added conspiracy. The combination of all of these acts were responsible for flooding the federal system with people convicted of low-level nonviolent drug offenses, all of which have had a disproportionate impact on people of color. As a precise result of law enforcement's decision to deploy its officers to the Black community, targeting young Tyrone standing on the corner and make 200 arrests. And Amani, the police and the prosecutors and the politicians, they rationalized that decision then and today by saying that they're responding to Miss Pearl, the elderly lady who lives on the corner. And the police say they came to, and they come to Black communities in full militarized gear because Miss Pearl calls them, and that is what she expects. They say that she wants them to immediately make those 200 arrests in her community, that she don't want to hear about any 2-month investigation, Tracy. But I submit that Ms. Pearl does not understand just what a mandatory minimum sentence is. That it doesn't matter if college student Kimber Smith gets caught up with the wrong guy and he beat her and threatened her family so bad that she was scared to come forward about his drug dealing. It doesn't matter that she's pregnant when thrown in prison. It doesn't matter that she never used or handled any drugs. The mandatory minimum drug law said that she had to serve time, 24 and a half years, students, of it. There are no mitigating or extenuating circumstances when it comes to mandatory minimum sentences. Ms. Pearl didn't understand what the crack versus powder 100-to-1 quantity ratio meant, that those convicted of selling 5 grams of crack cocaine received a mandatory prison term of 5 years, whereas it took 500 grams of powder cocaine to receive that same 5-year sentence. She didn't know that 1/3 of all federal cocaine cases involved an average weight of just 52 grams, the weight of an ordinary candy bar. She didn't understand the young Tyrone was not a major drug kingpin, and that there was a prison bed waiting for him based on the test scores that he made from when he was in the 3rd grade. And Todd, Ms. Pearl never even stopped to think of the adverse impact on political empowerment in the Black community as a result of 250,000 African-American men being stripped of the right to vote as a result of their felony conviction. She was ignorant of the termination of parental rights under the Adoption and Safe Families Act of 1997, the loss of school loans under the 1998 amendments to the Higher Education Act. She didn't know that her grandson could have her kicked out of public housing as a result of his drug conviction, that her daughter could be denied public assistance, or her son unable to find employment because of the infamous box, "Have you ever been convicted of a crime?" Indeed, It never dawned upon her that a young Black woman could be sent to Harvard, Judge Jackson, for the cost of what society pays for her incarceration. During the early 1990s, I remember walking the halls of Congress, and I'm not doing this, I'm just waiting for my water. Okay, during 1990, I remember walking the halls of Congress, lobbying against the various crime bills, which culminated in the Violent Crime Control and Safe Streets Act of 1994. This bill featured the largest expansion of the federal death penalty in modern times, the trying of 13-year-olds as adults, the gutting of Pell educational grants for prisoners, the implementation of the federal three strikes law, the refusal to address the crack powder disparity, and monetary assistance of money for states to lock up more and more people for longer periods of time in exchange for loads of money to build more prisons. And I characterize that 1994 crime bill as the granddaddy of all the crime bills. And Charlie Sullivan, you know, because you were around at the time, it was an anti-prisoner bill. It was an anti-youth bill, a bill which had a discriminatory impact on the African-American community. And I would say that conditioning the money to states that adopted truth in sentencing laws had the most far-reaching impact because it spurred an astronomical rise in prison construction across the country and, along with mandatory minimum sentences, lengthened the amount of time people would serve, solidifying the prison industrial complex and creating a mindset for imprisonment as the default punishment as opposed to consideration of alternatives to incarceration. The bill put 100,000 new cops on the streets, Tracy, and while this is often lauded as a positive development, more cops on the street also coincided with the ascendancy of the issue of racial profiling, which before the 1994 crime bill was not even a term that was part of the popular nomenclature. And there were many other provisions within that crime bill that advocates today, both progressive and conservatives, are seeking to undo. The Omnibus Violent Crime Control and Law Enforcement Act of 1994 indeed was a nightmare come true. And although touted as tough and smart, it was actually draconian and poorly conceived, filled with ineffective provisions that not only contained serious flaws, but invested scarce resources in more prisons and longer sentences without a concomitant reduction in crime or increase in public safety. The prevailing narrative at the time was tough on crime. Ted, you know that because you wrote about that way back then. A narrative which caused then-candidate Bill Clinton to leave his presidential campaign trail to oversee the execution of a mentally challenged man in Arkansas. The same narrative that popularized the myth of the child super predator. And 20 years later, we were in the midst of the dawning of a new narrative, one that was truly smart on crime. This new narrative resulted in the 2008 passage of the Second Chance Reentry legislation. It resulted in the Fair Sentencing Act of 2010 becoming law, which reduced the 100-to-1 ratio between crack and powder cocaine. It was exhilarating to not only witness, but help to achieve, along with my colleagues such as Charlie Sullivan, to help to achieve Todd Cox, Ed Chung, these winds of change. The narrative on criminal justice was indeed shifting, and justice system reform was not the lightning rod it once was decades ago. I was delighted, Ed, when former Attorney General Eric Holder announced his smart on crime policies, which focused federal prosecutions on large-scale traffickers as opposed to bit players. I said right on when President Obama became the first sitting president to visit a federal prison. I applauded his executive clemency initiative to provide relief to those serving inordinately lengthy mandatory minimum sentences, and I was thrilled with the bipartisan Senate introduction of comprehensive federal criminal justice legislation that appeared to have a very real chance of passage, the Sentencing Reform and Corrections Act. All of these reforms would have been unthinkable even a few years earlier. Some would not even have passed the laugh test for serious criminal justice reform. It was indeed a new day and a new narrative being formed. a year and a half ago, maybe it was 2 years, I don't remember, I sat in the Senate Judiciary Committee's hearing room witnessing the marking up of the Sentencing Reform and Corrections Act. Now, granted, this was not the bill that Nkechi Taifa would have written, but I supported it. I tweeted that it had a magical Goldilocks type of allure, not too hard on crime, not too soft, but just right to pass in this Congress, meaning last Congress, at that time. It was a carefully negotiated bipartisan compromise bill that sought to reduce some mandatory minimums, broaden the safety valve, made the Fair Sentencing Act and other provisions retroactive, expanded compassionate release, allowed for juvenile sealing and expungement, juvenile parole, and the limiting of juvenile solitary confinement. But all that was yesterday. A change in administration occurred, and the bill's future in its current state is quite uncertain. Today, Attorney General Sessions has dusted off policies from the past that directed prosecutors to charge arrestees with the most serious provable offense and resurrected such policies to obliterate the smart-on crime sentencing policies that were beginning to manifest. Attorney General Sessions' new DOJ charging and sentencing policy will not only reboost the destructive war on drugs, but also exacerbate racial disparities, soar the prison population, and increase costs to you and I as taxpayers. We must not allow this to happen. Congress must pass measures such as the Reverse Mass Incarceration Act, which is critical to incentivizing evidence-based decarceration programs that reduce crime and enhance public safety. Congress must eliminate mandatory minimums. Alma, I know that your boss spoke earlier today. Bobby Scott always stalwart for maintaining the principal stance of the abolition of mandatory minimums. We must change the federal drug conspiracy laws. Congress must create a second look mechanism by which lengthy sentences can be systematically reviewed as recommended by the bipartisan Colson Task Force. The Federal Bureau of Prisons must strengthen compassionate releases capacity to safely decrease the federal prison population. And the administration must consistently grant clemencies to deserving candidates, not people like a pile. Anyway, conclusion. Although we have journeyed from tough on crime during the 80s and 90s to a brief stint in smart on crime during the last term of the Obama administration, we seem to be slipping back to being dumb on crime during this current administration. However, Dean Fairfax, we are now at a point where we can openly discuss the data that we have known for years that sending people to prison and keeping them there for unconscionably lengthy periods of time does not make us safer, does not deter future crimes, does not promote successful reintegration back into our communities. With bipartisan alliances bringing together unlikely partners such as the Koch brothers and the ACLU, there is cover now to find better and more creative and more cost-effective ways to push the envelope to achieve change. Regardless, as I'm concluding, of whether we are motivated by fiscal, religious, big government, or racial concerns, we need to join together and raise the ante and have the audacity to advance creative solutions. The Miss Pearls of our community are crying out for all of us to take our place in continuing the struggle to bring smartness to criminal justice reform so that we can, in the words of Chief Justice Earl Warren, actualize the evolving standards of decency that mark the progress of a maturing society. Thank you.
Thank you all for your presentations. We do have a few minutes for questions, and I might start by trying to tie together the themes of some of the presentations that we've heard. Ms. Taifa talked about the war on drugs and whether we are now returning to the policies of the past, but if you've been watching the news lately, you will recognize that the president yesterday announced a public health crisis in the context of the opioid epidemic, and I wonder whether that suggests perhaps a ray of hope with respect to policies, thought processes, the treatment of addicts and the like? Are we really moving into a reversal with respect to the considerations of drugs in our society or not? Does anybody want to respond to that sort of general question?
I can start. I think that, it's laudable that I think that's getting the attention it deserves, but that conversation started last year when we were talking about comprehensive criminal justice reform in the context of its impact on African Americans. And we saw in that debate a contrast with how African Americans were treated during the crack cocaine epidemic and how, frankly, others were treated during the opioid epidemic. And I have to say it fell along racial lines. So I'm optimistic about what the announcement portended yesterday. I would hope that the same largesse and treatment of folks in the other camp, so to speak, who are suffering from effects of the many years of the war on drugs, I hope that largesse passes on to those communities as well, and that the policies that are being sort of developed along health and sort of social service treatments apply to those communities as well. And that's what we hoped, I think, last year. It's what we hope this year, and we just want there to be equitable treatment.
I just want to say ditto. I agree 100%. There needs to be a sea change in terms of what we're talking about in terms of enforcement. We're going to take a public health approach, and we're going to maintain the law enforcement approach. I'm hopeful that all of the different systems that Edson was talking about work together to make sure that it is a health approach. But on the other side, I also hope that all those who have been languishing in prison in years as a result of the tables being turned the other way have the opportunity to get out from under the imprisonment that they are in as a result of those policies back then.
Thank you. Mr. Chung, I found your proposal that we think about the policing end of this to be very intriguing, and I'm wondering to what extent do you think that this is likely, especially in the current environment in which police are under some scrutiny? Do you think that it's possible to really encourage people to become police officers? And is that really the best way to affect change? Well,
second question first. I'm not sure if it's the exact best way. I think I will say this though, not to minimize the question there. I think it has the possibility, but I didn't choose that to be the quickest or the easiest. But whenever we talk about criminal justice reform, the other side, and it's not an other side political or whatever, but the ideological other side always talks about police officers and officer safety. And it's one thing to have police chiefs stand up and talk about what it means because they're in charge of an entire organization. But coming from the Department of Justice, when we got a line officer to be able to talk about criminal justice reform or reforming public safety, the weight that carried was far greater than what a chief could talk about because they're talking about what they experience every single day. And so and this goes beyond the things that we've been talking about in recent past, even from the 21st Century Policing Task Force about guardian versus warrior. And I fully embrace guardian over the warrior concept. But in addition to that, when you have somebody who is thinking about their profession of policing in a way that is much more holistic and rooted and sees themselves in where they are in the system and the change that they can affect, I think it has the potential to make great change. Obviously, it's a concept, and there's a lot of work that can go behind it. But in a time where you have policing shortages, and Nkechi, we're not talking about the size. We're just talking about openings in police departments and whether or not all of them should be filled. That's a different question. But in a time where there are jobs that are to be had, and when there are times when young people are looking for meaningful jobs, I think it's something that definitely should be explored.
Let me ask Mr. Mr. Garrett, sort of shifting gears. We have different strands of criminal justice issues. I didn't know whether or not to be heartened by your remarks or depressed, because it seemed to me that you were suggesting that the evidence-based, data-based reforms, which people have tended to believe are helpful and hopeful insofar as they take us away from subjective views of culpability and people's length of punishment, et cetera, were not really the real solution because people were misusing the data or we're not analyzing it properly. So are you suggesting that we ditch it or that we fix it? And if so, how?
That's a great question, and yes, it's better to have information about what is happening in the criminal justice system and how that information is being used than to not have any, and to just say we're just going to trust the common sense of whoever it is. But the concern is that only if selective data is being collected and not on important topics that we need to understand better, or if it's not being evaluated by anyone with training, then you could replicate problems or maybe make them worse, actually. And so unfortunately, we don't have the kind of independent institutions in most places that are actually, it's their job to collect and analyze criminal justice data. Sometimes you have selective institutions, certain sentencing commissions that are looking at certain types of data, but not others. You have police agencies that are increasingly hiring data analysts to work within police departments, which is interesting and exciting, but there's not a lot of it. You don't have the kind of systematic reviews because there are just not enough studies done to study anything systematically. And so, for example, in the eyewitness evidence area, there are thousands of studies. I'm working on a project where we're doing a systematic review. It's going to take forever. It's a gigantic systematic review like you have in medicine, looking across lots of different studies that are conducted the same way, and you can learn something about which factors really impact a medical treatment or an eyewitness's memory versus others. But they're like, there's something called the Campbell collaboration, which uses systemic reviews methods and systematic reviews in criminal justice, and there are like a couple dozen of them, and a lot of them really wouldn't fit the criteria of what counts as a systematic review. And so then when you have a new problem and we need some data, what do? There's this study that just came out in DC. In DC, it's laudable. They have this DC lab to study data in DC government. They did a study of the use of body cams. They randomized it. It sounds like the design was pretty good. And then the criticism when it comes out, and they say, we don't really find a strong effect of the use of body cams on police and interactions or use of force. The criticism is, well, that's just one study in one police department. We need systematic data from other places. DC, there's been a lot of talk about the need to improve citizen-police interactions over years. Maybe the police officers were already sort of reacting to training that they were getting, and so the cameras didn't make a difference here or there because of other things in their training that had changed in the last few years. That's just one place, or a small department says, but we're a small department. We have very different interactions with citizens than they do in a city like DC. And so even when you do have some evidence, people either take a study the wrong way or they correctly observe that study might not be representative. So there are just huge, huge problems with the inadequacy of research in criminal justice. And then you have these situations when there's really pretty good data and it gets totally ignored by the relevant actors because they don't like it or don't feel like using it. So I don't know, I'm not optimistic or pessimistic, but we'll all have lots of interesting work to do.
Yes. Hi, Brandon. I have a question for Brandon Garrett. Okay, so I really enjoyed your story about the other Brandon as your opening, and I can't decide what to be afraid or what to be most concerned about in the story, right? Is it that the FBI was using the fingerprinting and that's inaccurate? Or is it that the FBI went into the database to try and predict who it was without any other kind of information, and perhaps to the exclusion? So basically that they were trying to predict to the exclusion of any of their other kind of problem-solving, I guess, techniques. I don't know. So what do you think? I mean, you scared me. I mean, it was like a scary story, but I just would love to hear more why?
Well, particularly scary because it's like, wow, they had fingerprint evidence verified by 3 scientists, right?
Yeah.
And they never make mistakes. But they did investigate, right? They investigated and they found out that this guy is a Muslim and clearly like has represented like some suspected terrorists. Like this is exactly the kind of person who fits the profile, we think, the psychological profile of a terrorist bomber. Unfortunately, he'd never actually, been to Spain or engaged in terrorist activities. I like that example because we think of fingerprinting as the symbol for reliable use of both scientific evidence in criminal cases. We have these big databases. People figure that that's great. We should have databases. It's more reliable maybe than just like asking around to see if anyone knows something. This is like an example of a scientific investigation gone incredibly wrong. But it's also an example of relying on common sense and hunches because there's a seeming use of data and databases, but really the area of fingerprinting has relied on, the technique involves the experience of a trained examiner, right? There's no like database or scientific method to describe what a fingerprint examiner does. They look at 2 prints and they look at them and they see things that look like they're the same, and based on their experience, they conclude it's a match. So it's a subjective black box judgment. And how good is someone at forming those judgments? Does experience doing it over the years just sort of destroy your eyesight and make you worse at it? Or actually do you hone your skills at identifying little things in fingerprints and become better at it? Or do judges become better at sentencing after experiencing lots of cases? Or do they develop more and more tunnel vision and they rubber stamp whatever the plea deal is? Right? And in lots of areas, we need to know, like, are professionals good at exercising their judgment? As lawyers, we don't like our judgment questioned. We don't like to be told, look, really what a reasonably effective lawyer would do is, like, hire a social worker because you're not any good at talking to foster parents and psychiatrists. And so, there's fields have been transformed by questioning of professional expertise, and there's an evidence-based revolution in medicine. It's not easy for doctors to be told that their traditional prescription habits aren't great, but that's I think what we need to go through.
Well,
and to some extent, what's happening.
It sounds like we still have reasons to be afraid, and we certainly have appreciated all of the presentations from today. It's a lot to think about, but please join me in thanking our panelists.
Thank you for watching Nkechi Taifa's Blast from the Past. Be sure to subscribe so that you can be notified when we post new content for your viewing pleasure. Once again, be sure to hit the subscribe and notification buttons now to her YouTube channel. For more information on Nkechi's content and engagements, and or to purchase her books and get her latest updates, please visit nkechitaifa.org.